So good evening, everyone. I'm Muskan Verma, a member of LawInternships team. I would like to welcome you all to all the participants to the webinar on how to crack AOR exam, and that would be taken by honorable guest Dr. Charuma. So I would firstly tell you about Law Internships. Law Internship is an online law school started off with a vision to help law students achieve their dreams internship under top-notch lawyers in law firm, corporate bodies, and etc. We strongly believe that true internship is one where students are allowed to actively participate and not just passive learning. We are happy to see students who have approached us and are placed under great mentors through us. With that, we also take pride in a vision for a full-fledged online law school, which shall provide extensive educational services. The objective is to forge a credible platform for the law aspirants who want to pursue and fulfill their educational requirements, that is, wholesome with the practical exposure to relevant skills. So, I would like to lend my heartiest welcome to Dr. Charu Mathur, who is a guest speaker for today's webinar. Welcome, ma'am.
Thank you, Muskan. Good evening, everyone.
Dr. Charu Mathur has a rich and diverse expertise in corporate, commercial, civil, criminal, and constitutional matters. She is advocate on record in Supreme Court of India. Dr. Mathur is a regular practitioner before the Honorable Supreme Court and has represented many cricketing bodies, educational institutes like IIT Jodhpur, NLU Jodhpur, and etc. Dr. Mathur is probably the only person to develop a course on essentials as well as on practical aspects of insolvency and bankruptcy code. She is a frequent speaker at various forums. Dr. Charu has conducts training in professional ethics for insolvency professionals. There is no one better than Dr. Mathur who could guide us better on how to crack AOR exam, and we all have got this precious opportunity to seek her guidance. So I have some instructions for the participants. So if the participants have any queries in between, they could post their queries in the chat box or raise their hand, and Dr. Mathur could take the doubts as she wants. I would also like to respect that please save your doubts for the Q&A session and firstly listen to what the ma'am says nicely before. Now I would like to request Dr. Charu Mathur to take over the session. Thank you, ma'am.
Thank you, Muskan. Thank you for your kind introduction, and thank you for inviting me to speak on this important topic. Now, as far as being an AOR is concerned, or being an advocate on record is concerned, there are certain prerequisites that you are required to fulfill. So essentially, after you complete your law and it is 4 years, your post-professional qualification, right? You can enroll with an advocate on record with 10 years of standing, start your training under him, take a certificate from him that you're commencing the certificate training with him for 1 year. And after the end of 1 year, that is after that you have been in profession for 5 years, you are entitled to write the exam for advocates on record. Now, to be an advocate on record, it is in Supreme Court, it is only advocates on record who can file as well as plead. Any other advocate, he can or she can appear only when there is an advocate on record. So this is one aspect that you need to understand. For Supreme Court, advocate on record is must if you want to act, if you want to plead, and if you want to file. So other advocates, they act on the instructions by advocates on record. Now, to write this paper, to clear this exam, you have to write 4 papers. Now, there is one paper called Practice and Procedure, that is your paper 1. Paper 2 is your drafting paper. Paper 3 is Professional Ethics and Advocacy. And paper 4 is a Leading Cases paper. Now, this exam is fairly challenging. So initially, so even if you look at 70 plus years of Supreme Court being in existence, so you will see that there are hardly in all 3,000 up till date, right from number one till date, there are around 3,000 advocates in advocate on record that has been produced by the Supreme Court. Initially, the pass rate was they were making 2 or 3 advocates on record every year. Then by the time I passed, there were around 20 AORs every year. And last year, last result which had come, so they had made around 200 plus AORs. So that you must consider that even the passing rate for this exam at one point of a time was less than 1%. Now they have increased it to around 20% or so. They have been little bit liberal in the past few years. Now, this is one exam for which you have to prepare very well. If you are practicing in Supreme Court, you will be well aware with the practice of the Supreme Court, how the file move, how you should file, what is the format, what are the requirements, how to go to registry, get your matters filed. The plus, as a junior lawyer, you should take actively, you should go to registry, you should do the drafting. So this I'm telling, like if you have aimed to become AOR, your life will become easier if you do actual work, right? And even for the interns, my suggestion is you should have more strong theoretical base, and for practical exercise only in the 4th and 5th year you should come to courts, and in court also you try to go out and see how the courts actually function. Right now in Supreme Court, there is a limited entry that is given. Interns are not allowed right now within the court premises, nor are the clients because of the COVID situation. So you should take an advantage of at least exploring the court, why it is there, why this procedure is being done. Now coming on to your papers, how to prepare for them, right? So for your practice and procedure, you have got Bear Act you have to go through. There are Supreme Court Rules 2013. Earlier we used to have Supreme Court Rules 1966. So there is a Bear Act for the same. You have to understand the procedure for that. You have to understand who is an advocate under the Supreme Court rules, who is advocate on record on the Supreme Court rules, who can be designated as a senior. So all those things you have to understand. Then you have to understand like things like how does registry function, right? How you can move application, what are various type of writs that can be filed, what are the various jurisdictions that Supreme Court can exercise. You have to look at its original jurisdiction, extraordinary original jurisdiction. You have to look at advisory jurisdiction. You have to look at when reference can be made. You have to look at appellate and extraordinary appellate jurisdiction. So these are some of the important things that you have to understand. How statutory appeals can come directly to the Supreme Court. What are the limitations? What is the court fee? So many things you will learn. If you're in active practice in Supreme Court, you will learn by actually doing it, right? And otherwise, there is a book by EBC on practice and procedure. I think that is the only book available right now. So that you can take, it is of a great insight. Apart from that, Supreme Court Bar Association and Supreme Court Advocates on Record Association, they also organize lectures before the examination. And I also conduct certain, this course I'm conducting with Eastern Book Company for AOR preparation. So this is some of the background material that I can give you. You can purchase the study material from SCBA office as well. So this is one on the practice and procedure. Now coming on to drafting paper. Now one thing you need to understand that Supreme Court and Advocates on Record examination is a tough. There is a board of examination which comprises of the senior most judges, right? And some of the senior most advocates who are part of that. So the board of examination, it sets the paper, and your paper is evaluated by the senior most advocates. They will see how you write. One very important tip that I need to give you is this is a handwritten examination. And by the time you are 5 years into practice in the profession, you have forgotten how to write with your pen and paper. So either you are typing or you are dictating. So most of the people have challenge in managing the time management for the examination is really crucial. So they are not able to manage how to write. They are not in the practice of writing for 3 hours continuously. And papers are fairly challenging. So coming back to paper 2, which is your drafting paper. Now for drafting paper, you have to actually know the format of the Supreme Court. What is this format in which the Supreme Court appears? So you might be asked to draft a special leave petition, your SLP under civil application, criminal application. You might be asked to draft a civil appeal. You might also be asked to draft a writ petition. You might be asked to file a transfer petition. Certain applications you can ask to file. But what is very important is, see, you have got only 3 hours to attempt 4 questions. So you cannot, they will obviously not be asking you to write everything right from the first title till the praise. So you have to read the question very, very carefully to understand what they are asking. What is it that they want to know? What is it that they have asked? In some question, you might be asked only to draft the prayer clause. In some, they will ask you not to write list of date and synopsis, just frame the questions of law. So you have to read problem very carefully. Keep a tab on the time that you don't spend. Like last year, we had a question which was very tough. And usually you get a interchoice between the questions, like 1A or 1B you have to do. So in this case, there was a question which was essentially a tough one, and people spent hour on that one question and they could not finish. So you need to know when to move ahead from this paper, from the question paper. If you don't know, just don't get stuck on it, move on. And for paper 2, it is a 3-hour paper plus half an hour is given to you to read the question paper and to analyze it. So this again this is again, as I told you, is checked by senior advocates. So again, everybody has their own style of drafting. So it becomes very subjective as to what to write. It is a good idea to pepper your petition, what has been asked, with the relevant case laws. So when you will prepare for your paper for leading cases, you will get many ideas that this is the case which I can cite. Now moving on to your paper 3, which is professional ethics and advocacy. Earlier they used to have a paper on accountancy as well, but now they have removed the paper of this portion of accountancy. So it is only your professional ethics as well as your this thing, advocacy. For this, you have to know your Advocates Act. You have to know certain bar council rules. There are certain judgments which have come. Well, there is no list provided as such, but you are required to know certain judgment about what is a lawyer's misconduct, what is a contempt, when can a contempt proceedings be initiated, then what are the 7 limbs of advocacy, and so on. There are some articles that you need to put, and it is just a test on your moral dilemmas are given to you. Suppose a client comes and says to you, I have committed murder, save me. So as a lawyer, what will be your duty? Should you take the case, or should you report him to the police, or what should you do? Right? So there can be situational, circumstantial cases that can be given to. Apart from that, there are standard judgments which you are supposed to read on the professional ethics. Like there have been cases where the lawyers have been scrambling to snatch a file from the litigant, and they started beating each other. So matter reached the Supreme Court, and they said that this is a case which requires a complete misconduct on part of lawyers. It shows our profession in the bad light. So what are the steps that can be taken? Then you have to keep an eye on the contemporary threats, like on your media trial, live tweeting, right? And writing articles. So does it interfere with the dispensation of justice? So these are some of the points that you need to remember. Now coming on to paper 4, leading cases paper. Now this is one paper that most of the candidates find it very challenging. But to tell you the truth, if you have at least skimmed through the head notes which are provided to you even in the examination, it is not that tough. But my suggestion to you, if you have time to go ahead in your hand, then you must go through these judgments. So every year, Supreme Court comes with the list of cases that they will have taken up as a leading cases. So last year when exam was conducted, they added 14 more cases. Now, I remember when we started, for my examination, we had around 70, 71 cases. And we had cases right from the beginning of the Supreme Court, from the 50s itself. While in the last year paper, essentially they have started from, I think Keshwanand Bharti was the first judgment from 73 onwards that they have started, and they have gone up to the recent judgments. So you have to keep a tab on the latest judgment. Now with the technology and so much information available online in audio as well as video format, so if you can just keep a tab on the various news portals, law news portals, then that can also be of a very big help. But I suggest that you read these leading cases, because that is how you will get your vocabulary to make your drafting effective. Right? You need to have your own language as a lawyer, that this is what I'm supposed to write in the drafting, or this is a question which is asked, that is how I have to answer. So my sincere suggestion to you is try to read these judgments. And when you have to answer, so there is not that you will get a straightforward question. What was held, what was in Keshwanand Bharti, that they are not going to ask you. They can ask you in which judgment basic structure theory had come and how it was followed in the subsequent cases. So you have to learn how to knit your answer. It won't be a direct question, like if they can ask you upon anticipatory bail. So you have to know that in the leading case, that is Shoshila Agarwal's judgment, where deals with the anticipatory bail. Or they can ask you on the privacy. You have to know it is a Putaswamy judgment that you need to know. Though these bear help from the Supreme Court report, SCR will be provided to you. But if you don't know where to look for, then it is not worth exercise to even to have the case head notes with you that you can access. So even if entire information is available to you in your front of you, if you have not gone through it at least once or twice, you will not know where to look for what. So this is all about the 4 papers that you have to understand. Now, one more important thing is, if you want to start your career as an advocate on record, there are certain requirements. You need to have your office within the 16-kilometer radius of the Supreme Court, and you have to have your registered clerk. Now, why it is important to have office or the premise within the premises or nearby? The reason for the same is, see, as an advocate on record, you are accountable to Supreme Court, and you are accountable to Supreme Court personally. If there is fee, etc., that is to be paid, suppose your client has not paid, then it is a personal liability as an advocate on record. So you see, Supreme Court get matters from all over India, and they need someone responsible who is answerable to Supreme Court, who is within in the reach of the Supreme Court, where they can reach out to a person. So advocates on record, when you prepare for the paper 1, you have to learn which matters can go to chamber judge, which matters can go to registrar, and all the nitty-gritties you are supposed to understand. When can bail go if it to a single judge, when he can decide it finally, when transfer petition, they have recently changed. Earlier it used to go before the division bench, right? Now it goes before the single judge. So why, from where do we get the powers to make these rules? So you have to go to Article 145 of the Constitution to understand that is the where Supreme Court derives its power. You will be confronted with questions. Suppose President asks a reference, makes a reference to the Supreme Court regarding a certain issue and the advisory jurisdiction. Does Supreme Court has to answer that? Can it refuse to do so? So the answer is Supreme Court can refuse to do so. You can get whether such advisory jurisdiction, right? Whether it is a law within the meaning of Article 141 or not, right? Or is it a binding decision or not? So these are some of the issues that you need to understand while preparing for your question. So it is not that they will ask you to write what is said in order 6, what is said in that. It will always be an application based. Now, if you are actually practicing in Supreme Court day in and day out, you will be knowing it by observing, right? So, just sitting in the office, rather you should be mobile if you're coming for your internship, right? Just don't come and sit in a chamber. Like in Supreme Court, we have got really small chambers, right? And many people keep on coming and going. Just don't overcrowd the chambers. Just go meet and see how actual things are done. Until and unless you do the things, the same cannot be said to be, you won't be having the practical experience of the same.
Ma'am, you got mute.
Yeah, sorry. Right. So these are some of the issues that I just wanted to put you for your AOR examination, how to crack. And one very important thing is the past papers are available. Try to solve them, go through them, and then you can understand. Now, as far as our preparation goes, there are people who actually sit for at home for 1 hour and prepare for 1 year and prepare for it. There are people who prepare within in the summer break, 30 days, 40 days, and there are people who just study for 15 days and they are able to crack. But within 15 days are those people who are actually doing the work in the court day in and day out. So if you have any queries, now I'm opening the stage to you. You can just ask your queries.
Ma'am, Muskan will be reading out few questions which we have received from the participants.
Sure.
Muskan, please go ahead by one.
Yes, ma'am. Ma'am, is there any difference between due process of law and procedure established by law?
Sorry, what? Can you just come again?
Is there any difference between due process of law and the procedure established by law?
See, when there is a due process of law, it is a concept that comes to you that this is a procedural which has to be followed. There has to be fairness. So it might not be written that there has to be natural justice should be followed or it should not be followed. But it implies that if there are principles of natural justice to be followed, they have to be followed. So justice should not only be done, it should appears to be done also. It should not be just that if there is things like natural justice, should it be followed or not followed? It should be followed. It might not be written, but it is inherent that it should be followed. Now coming on to what is the procedure? If it has been established, it should be followed. So if it requires that you have to give a notice and you don't give a notice, then it has to be followed, right? So there is a difference between due process of law and the procedure to be followed by law.
Just a second, Muskan. I think Ritu has raised her hand. Ritu, do you want to ask anything? Please unmute yourself.
Hello, good evening, ma'am. My name is Ritu Padina, and I have a question. Like, what is the difference between an advocate and an AOR?
See, advocate, if you look at Advocates Act 1961, once you clear your law exam, you do your bar examination, AIP, and you enroll, you are advocate, right? But to become an advocate on record on Supreme Court, you have to pass this exam after 5 years of passing your advocate exam. As an advocate, you can just go and argue in Supreme Court from day one. But to become an AOR, you have to pass the exam and you can file the matter only through an AOR. So an advocate on record is one who gets a right to file, act and plead, right? And other lawyers, they act actually on the instructions of AOR. I hope I answered your question. Yeah.
So can an advocate other than AOR work on a case for their client?
They can, but filing will always be done by AOR.
Okay.
Anybody else?
Ma'am, second question is, what could be the procedure in case of a case which is first of its kind?
See, there have been cases, like I'll give you example of Vishaka versus state of Rajasthan. Now, this was a case where this woman was brutally gang raped. She was working and she was an Anganwadi worker. So when this matter came to Supreme Court, there was no guidelines regarding the sexual harassment at the workplace. So it was something new that court was doing for the very first time. So they laid down the guidelines, and these guidelines came in 1997, and court said that you have to take care of this till you form these guidelines will serve you till you form the legislation. Legislation, as you are aware, came only in 2013 when the POSH Act came. So this was one of the kind where Supreme Court can use its power. Again, another example I can give you is when you have a mutual consent divorce, there is a cooling off period. But Supreme Court in many cases has waived off that cooling off period. They have powers under Article 142 to do complete justice between the parties. Likewise, if you look at environment law jurisprudence, the Supreme Court has evolved a new kind of a writ, continuous mandamus, right? So writ, are of 5 types. So in the mandamus, they said that this is a command that we do. But for the PIL matters, they came up with this concept of continuous mandamus. So with the continuous mandamus, the court were able to monitor the issues continuously. So MC Mehta's writ is of 1985 and it is still going on. Right? So whatever new issues are coming, they are taken care of. Yeah, Muskan.
Ma'am, I've got some questions in the chat box. Can I?
Yeah, please.
Can CGI appoint directly someone AOR at the Supreme Court?
To become an AOR, you have to pass the examination. Plus, if you are a solicitor from Bombay Incorporated Law Society, it gets waived off. You can be directly admitted as an AOR. And in exceptional circumstances, CJI has a power to do so. But I don't think it has ever been used.
Okay, ma'am. And is there any exceptions to lawyer for not giving exam and training to become an AOR?
So just I gave you the example. The only exception is if you are a solicitor with Bombay Incorporated Law Society or if CJI gives an exemption.
Okay, ma'am. So, ma'am, why is the process system of law in India is very slow?
See, India is a vast country and we have, like any other country, like most of those countries, we don't have the issue of judicial review. Judicial review is a very powerful tool that has made Indian courts very powerful. Now, coming on to delay, we have to have a better docket management of our files, how they move. But look at the amount of work that is there. So every day, a Supreme Court judge, like Monday and Friday, are a miscellaneous day where the fresh SLPs are listed. So every day around on Monday and Friday, you will find around 40 to 60 cases listed before a Supreme Court judge, a bench of Supreme Court judge. Now the strength is 34, so you can roughly say there are 16 to 17 courts. So if you multiply that number by, even go by 30, not even 60, then you have to realize such a large amount of cases are pending even before Supreme Court. So even as we speak, around 72,000 cases are pending before Supreme Court. And before High Courts, it's large number. And if you go to trial courts, you will find that it is way beyond in crores that cases are pending. So our procedure is, and the procedure is very tough to get. Even like if you get a decree also, right, to get it executed is another ball game. Khare sir is there, he will be able to tell us that also, that to execute, even if you get a decree, to get it executed is altogether a different ball game. So I agree with you, like even for the arbitration, I think it is very much abused. For every arbitration award, you come to court. So it is a large chunk is to be faced by the litigants also, that they themselves never want to put a stop to the litigation. Yeah. Any other query? I think there is something Srishti is asking. Any age, let's say there is no age limit to AOR, but you can give 5 attempts are provided to you. Achha, one important thing is to pass this examination, you need to get, each examination is of 100 marks, each paper. 4 papers of 400 marks, you need to get in aggregate 60%. Plus you need to have 50% marks in each paper individually. Suppose you get aggregate 60 and you don't get 50% in one of the papers and your mark range is between 41 to 49. Then you get a chance to appear only in one of the papers. But suppose you get aggregate 60 and in one paper you got 30 only, then you have to write all the 4 papers. And suppose you don't clear any paper, right? In none of the paper you are able to clear, then you will be debarred for further examination. And thank you for asking that question. I should have taken care of that for the first instance. Yeah, go ahead.
Ma'am, Sonali has asked that do we have firms who also act as AOR and file cases in Supreme Court with the name of AOR firms?
Yeah, so you can do that. 2 AORs or a 1 AOR and 1 advocate on record, they can also form a law firm and then they can do that. Recently, we had an issue coming before Supreme Court where an individual lawyer filed his case at chamber of such and such. So Justice Sanjay Kishan Paul said that this is not permissible, and then this analyzed, and then they finally allowed, okay, you can even do so. But otherwise, the rules provided who a firm can be, an advocates on record firm can be formed, but a senior advocate cannot be a partner at such firm.
Ma'am, I just have a doubt, like how a younger lawyer who have just graduated from universities after 3 or 5 years of courses, can it be difficult for them to become a successful lawyer in Supreme Court?
See, it is a journey, right? You have to clear your examination, you have to get the cases, you have to work really hard for giving that. See, there is one game to clear the examination, and it is altogether a different ball game to establish your practice. So whether you come from a 3-year course or 5-year course, it really doesn't matter at the end of the day. It depends on how much work you can generate. I can give you my own personal experience. See, I got outstanding grades in IPR. But what the work I got was educational work and service law matters. I didn't get trademarks or patents or everything to do. So we don't select the work. Work is what you follow. And that is how one way is you join a certain senior who is doing that kind of a work. Suppose I wanted to do patent, I should have joined only a firm that was doing patents work. So work for Supreme Court, you need to have your own feeding areas, your feeding state from where you will get the work. Right?
Recently, the Bar Council of India, just a single question. Recently, the Bar Council of India has informed the Supreme Court that qualifying the All India Bar Council examination is not sufficient enough to practice directly in Supreme Court. So, ma'am, what is the criteria now?
So criteria, they have not changed. Earlier, there was this thing, embargo had been put on that if you are not a lawyer with 1 year's experience, you cannot go and argue before Supreme Court, but nobody actually followed it as such. So even you are one-day lawyer, come and argue. Now, these days, the law students are filing writ petitions every day. But only idea is that whatever you do, it should be meticulously prepared.
Ma'am, what is the importance of the due process of law under Article 21 with relevant case laws?
See, for the due process of law, you have to follow, if you look at any of the cases under Article 21. So there has to be a process, like even if you go for a right from your Bandhwa Mukti Morcha to any other case that you go, it has to be followed meticulously. That due process of law has to be followed in not just in the letter, but also in spirit. So this is all I can say to you about at this point of our time. Right, for due process, we have to do a separate webinar altogether. Yeah, Vaibhav, please ask.
As you said that in AOR paper, the paper is checked by the senior advocates. So do senior advocates also need an AOR to file their case in Supreme Court?
Yeah, they cannot. Like senior advocate, he cannot ideally see. Now, as a senior advocate, there are certain embargo which is put upon. You cannot meet your clients directly. You cannot file your matters, and you always act on instructions. So a senior advocate is always being engaged by advocate on record. Even when we raise our bill, a senior advocate does not raise bill directly on the client. He raises on the AOR and AOR raises on the client.
Thank you, ma'am.
Sure.
There is a question that how the courts have gradually changed the meaning of procedure established by law through its judgment.
See, I have just given you procedure established by law. Then there is legislative vacuum is there. Then they have stepped in. I have just given you the example of Vishakha's case. Then I have given you example of mutual consent divorce, which is their cooling off period. So procedure, if it is established by law, it is the duty of court that if there is some procedure which is there, then the procedure has to be followed. Suppose in the criminal law, it says that they have to give you a notice before arresting you, pre-arrest notice if it is required, right? Then they have to follow. Now, there have been judgments like Arnesh Kumar, which says that FIR is to be, the notice is to be given, or in Lalita Kumari, they have said that FIR is to be registered. So these are the things which are there in the process and that is given. And Supreme Court has said that if you don't follow this, then it will be a abuse of process of law. Like even if you go back to your Menka Gandhi's case, that is a classic case that you should realize that even if a passport of a person is to be impounded, it has to be done while following a process of law. There have been cases on natural justice like your R.D. Shetty and all, where if a notice requirement is there, if it is not given, there is an infringement of principles of natural justice and same has to be followed.
Bhargavi is asking that what is your personal advice to crack the exam?
My personal advice is first you read the leading cases. And if you are practicing in Supreme Court, just don't sit in a chamber or office, just move around, go to registry and see actual process. Observe the court, how it is done. Second tip is go through the past papers. And third and the most important tip is practice the paper. Time yourself that how many questions you can finish in 3 hours. See, what it matters is that you clear the AOR exam. It doesn't matter whether you have topped or you have not topped. The idea is you get a AOR certificate to practice before the Supreme Court, as to file before the Supreme Court. So that is a must.
Ma'am,
I just
we
have a last
received
question.
Yeah, sure, Ritu, please go ahead.
Okay. Nowadays, there are a lot of young independent lawyers who are practicing independently without the guidance of senior. So is it important to have a senior?
Yes, you need somebody, you need a mentor to guide you. It is very important. I have seen particularly in Supreme Court, most of the people, they just come and start their practice, right? Because to live in Delhi, to sustain yourself in Delhi is not an easy task, right? And it is wrong on the part of seniors also that they pay pittance to the juniors when they join the profession. But you must realize that as individual lawyer, he won't be able to give you as much salary as a law firm which is doing transactional work will be given. So you have to balance it. But joining a senior is a must. A horse is known by its stable.
So is it related to money?
Not money. You have to get your grounding. How will you know the law? Until and unless you observe somebody, you work with somebody, nobody is going to give you a file if you are not in somebody's office. Why will anybody will let you touch their files also? That is a lot of confidential information. And there has always been a Guru Shishya Parampara that you have to learn from the seniors. But in Supreme Court, there are many lawyers who have started from day one on their own, and they have been quite successful. But at the same time, I'll tell you that they themselves are coming from relatively privileged background. But if you ask my personal opinion, it is a must that you have a good. You must join someone's chamber, and you have to work as if you are learning under a teacher. These days, what I see is कि ठीक है हम इनसे काम सीख के चले जाते हैं, इनकी फाइल ले लेते हैं या इनसे formats ले लेते हैं. So that kind of attitude is there. I won't deny that.
Ma'am, my question is that what is the reason that young lawyers like work independently?
See, whatever fees come, they want to keep it for themselves. They don't want to get it shared. That is the reason. Or they think, see, this is one problem that you come like,
So basically,
you know,
it is
when you
related
come
to
from,
money.
no, I tell you, once you come, there is a lot of ego has to be, the high-headedness of law student has to be put down. See, this is a court of law, not your moot court, first thing. So one day, the first day the lawyer comes, they start just arguing themselves. Okay, this is this, this is this. So you have to see for what purpose the matter is listed. I'll give you my own example. When I started, I was having my first appearance, and I was gone full throttle before the judge saying that this is this, this is this, this is this. I was fully ready to argue it as a final matter. But judge said, did you check the causes? What was it listed for? It was just listed for some IA. That was a limited purpose for which it was listed on that particular day. And my ego got very much settled. Fine, this is not your moot court where you can just go and argue anything. So it is what I appreciate in today's students, that they have a very good research skill. They are far better than us in the terms of writing, in terms of organizing themselves, in being aware about what we were. And I'm sure even the generation previous to us, you are far more aware generation. But there is certain thing which comes only with experience. You have to understand what to do with court, how to understand. You cannot just go and start shouting in the court. You have to take order from the judge. You have to be very respectful towards the judge. You have to be very respectful towards your opponent. And in actual court, the artificiality of your moot court, it doesn't work. Right? So you have to actually observe and learn. So that is very important. And then there are people who believe that I know everything and they start their own practice. Some of them are able to get good work also because they have feeding state. They have got somebody who can send them cases. But my suggestion would still be to join someone. And in this profession, seniors generally, they don't pay much as compared to the law.
Yes, Sonali, you can ask.
Ma'am, is there any salary for AOR?
See, advocate by definition are independent person. So there is no salary as such for AOR. You charge your fees. However, you can become a retainer with certain companies, with certain firms, then and then they can have a fixed income. But to survive in Delhi, you need to have a certain income.
So can a firm be an AOR?
What? Firms can also, firms can also be AOR firms.
Ma'am, there is a question in the chat box. So Mary Singh is asking, which is better, to be in a law firm or with a senior in his chamber?
See, again, it depends on a lot of situations. See, if you can be with the topmost seniors, the topmost, he doesn't pay you anything, but you get to learn a lot. But then you will be seeing your friends who have just passed from the law firm and they have joined a law firm, they might be getting 25,000, 50,000, 1.5 lakhs or something. And you might not be getting even 5,000 rupees. So that much difference is there. But
we have
personally,
other questions?
Yeah. And personally speaking, there are firms also which are litigating firms and non-litigating firms also. So it's a good idea to join a litigating firm where they can take care of your expenses as well. And once you are valuable to a senior, senior will also pay. There are seniors who actually pay up to 2.5 lakh, 5 lakhs, 7 lakhs also to their juniors. But for that, it cannot be paid to a fresher. And this I'm talking about a per month salary, not per annum. So route to be an advocate is a tough one as compared to the transactional firm lawyers. But in the end of the day, as a transactional firm lawyers, you can get only up to a certain rates. But when you are your own master, you can decide how much you want to work, what is your flexibility, what is your fee you want to charge, what are the matters that are important to you. So all those issues are there.
Ma'am, one question from my side too, ma'am. why there is a very less number of AOR in Supreme Court? I mean, as far as I know, as far as the last data, only 3,000 even below than the 3,000 advocates are advocate on record, I can say. And when it comes to the number of advocates, I can say 15 lakh plus advocates are there in India, but only 3,000. So is there any quality?
Yeah, there is a quality check. As I told you in the starting of the webinar, this exam is quite tough and it used to be very, very tough a decade back. So when we started with this AOR thing, so it was barely 1 or 2 AORs they were making in a year. By the time I became an AOR in 2007 or so, there were around 20 AORs they are making. And last year they made around 200.
Oh, so last year in the year 2021, there were one exam of AOR because in the year
last year means the last exam, 19. That was 2019.
19, because due to this pandemic, there were no exam in the
no
year.
Exam was conducted last year and result is awaited.
Oh yeah. So I hope this time Supreme Court will allow more and more AOR, because last year we didn't have any exam. Now, is there any rule of Supreme Court Bar Association to conduct this examination of AOR, or
No.
only?
See, this is under the Supreme Court examination. Regulations are also given. What are the examination which have to be conducted? And the Board of Examiners is the senior most loyal judges of the Supreme Court, who are the Board of Examiners. Then under them, they co-opt 2 senior lawyers.
Okay.
So there has to be a quality check. And now I am not particularly very happy with the fact that they are making so many AORs. It has to be a quality check. Now you can get an AOR who would charge you a bare minimum and they will put a signature and just won't see what is written in that petition. So there have been strictures which have been passed. Even your sanat can be cancelled for that, not just your AOR thing. So AOR should not be, and even the way the courts are designating seniors, like you are getting a senior, other person is getting designated as a senior and not getting any work.
Correct, that's true.
True. So and like whatever you do, the dignity of that work should be maintained. Like if the profession says that as a senior you should not meet a client, or you should not you should not do the drafting, then it should be like that only. But you will find many seniors, they are meeting the client, they are doing the drafting, and even they are raising the bill for their drafting. So this is patently wrong. I mean, you are demeaning your profession.
Perfect. And ma'am, this particular criteria of 16 kilometer premises wala criteria which you have told about in the webinar, ma'am, is this compulsory to do this?
So that whenever the Supreme Court calls you, you should be able to come within that time.
Okay. And so, ma'am, so what about the advocates who are AOR but they are practicing in some other state? How they can manage to,
they give their local address in Delhi. You have to have a registered clerk as well.
They need to register clerk as well. Correct, ma'am.
Not any clerk will do. It has to be a registered clerk. So only a registered clerk of a particular AOR can go in the registry for that particular matter of the AOR. Not anybody else.
Yeah. So okay, that's fair enough.
Yeah.
So
any other queries?
Yeah. Do you have any other queries? Please feel free to ask. Okay, Muskan, you can proceed ahead. with your work.
So I would like to thank all the participants, and I would like to thank Dr. Charu Mathur, who took out her precious time to give this session to all the participants. I want to thank you all on the behalf of the Law Internships team. Thank you.
Thank you.
Thank you so
Have a
much.
good day.